So once again, welcome everyone to today's webinar, and thank you for taking the time to join us. I'm going to start the presentation now. So for those of you who haven't met me before, my name is Kim Baker. I'm HR consultant at RBHR Consultancy, and I'm going to be presenting today's Subject Access Request webinar. I'm also joined behind the scenes by my colleague Beck, and she'll be operating the presentation slides. So let's take a look at today's webinar agenda. We're going to be discussing the Information Commissioner's Office, what is a subject access request, also known as a SAR, what to do if you receive one, how to respond to a SAR, what information should be provided. We'll talk about frequently asked questions as well, best practice communication, and how to protect your business going forward. Hey. So the Information Commissioner's Office, also known as the ICO, upholds information rights in the public interest. It enforces laws on communications, networking, and data protection, including the European Union's General Data Protection, GDPR. The ICO promotes best practices for personal data handling, offers data protection guidance, addresses complaints, and registers data managing organisations. So what is a subject access request, also known as a SAR? So the ICO states the right of access, commonly referred to as a subject access request, gives someone the right to obtain a copy of their personal information from your organisation. This includes where you got their information from, what you're using it for, and who you're sharing it with. And they're entitled to ask for this information under Article 15 of the UK General Data Protection Regulation, also known as GDPR. So an employee asks for access to performance reviews, disciplinary records, emails mentioning them, etc. That would qualify as a SAR. And it's often used by both past and present employees due to disagreements over treatment or potential grievances, along with collecting evidence for claims of discrimination or unfair dismissal. Next slide, please, Beck. So this is one example of how a subject access request can be received into an organisation. However, not all SAR requests are straightforward. Additionally, not all requests for personal information are SARs. For example, if an employee asks for a copy of their contract of employment or their monthly payslip, this wouldn't be classed as a SAR because it's something they can ask for general information during the course of their employment. Next slide, please, Beck. So, formal request requirements. The previous slide gives a perfect example of a SAR, however, it's not always obvious that it's a subject access request or a SAR, particularly as anyone can submit a SAR verbally or in writing, even through social media. The ICO, the Information Commissioner's Office, don't stipulate the format of a valid subject access request, and there is no need for the requester to use specific terms like subject access request, right of access, or Article 15 of the UK GDPR. And the request can go to any department or person in your organisation. It doesn't need to be directed to a particular contact. So anyone can phone up and say, I want to make a subject access request. So how do you respond to a SAR? So first off, you acknowledge the request. So you would confirm receipt and clarify the scope if needed. So when we talk about the scope, an example would be if the request is quite vast. So and if employee is asking for all correspondence where their name has been mentioned since the start of their employment, and they've been employed by you for 10 years, then obviously there's going to be a vast amount of data to go through. So you can then respond and ask them, check whether they really want 10 years worth of data, or perhaps ask them to narrow down the time frame of the request or for specific information. So if it relates to a disciplinary or a grievance, it might be that they just want the information that relates to that, or they might just want the information for the past 12 months. But they are also quite within their rights to turn around and say they want the whole 10 years. So number 2, you would verify their identity. So ensure the requester's identity is confirmed to protect data security. On some occasions, somebody might request a SAR on behalf of somebody else. So you need to make sure that the other person is aware that they're requesting it on their behalf and that it's all above board and you're not doing anything untoward. So that's when you can ask for identity. Number 3, gather information. So collect all relevant personal data, ensuring compliance with data protection rules. Number 4, review exemptions. So assess if any data is exempt from disclosure. So third-party data, legally privileged information. So to give you an example, I once made a subject access request to a car insurance company to find out details of an accident I'd apparently been involved in. When I received the information from the insurance company, they'd redacted all of the other parties' personal details except for one document, the engineer's report, making it obvious who made the complaint. So this information, the third-party data, should have been fully redacted prior to being shared with me. Number 5, provide a response. So supply the data in a clear format along with necessary information. So the processing purpose, the rights, and we'll talk about that more in a later slide. So what information must we provide in response to a SAR? So you must provide a copy of the individual's personal data along with the following information. So the purposes of the processing, the categories of personal data concerned, the recipients or categories of recipients, the retention period or criteria used to determine it, existence of the right to request rectification, erasure or restriction, information on the source of the data if it was not collected directly from the individual. But to be fair, most of the above information will be included with an organisation's privacy notice. So this should be enclosed alongside the requested personal data. And if you've got one of those, it will save you a lot of time going forward. And obviously we've got templates and things we can provide you with. The time frames. It's important that you respond to a subject access request within a month of receiving it. So for example, if you received it on the 20th of November, you would need to respond by the 20th of December. And the time starts from the moment the SAR is received unless identity verification is needed. You can request an extension. So if the SAR is complex, like we talked about earlier, such as a large amount of data or it spans several years, you can request an extension of up to 2 additional months. However, the extension must be requested within the first month. So here at RBHR, we suggest that if you get a SAR, you start working on it as soon as possible because it can take you by surprise and it can take a long time to prepare the information. So, can a subject access request be refused? Oh, it's unlikely that you can fully refuse a subject access request, but there are circumstances where it may be possible, such as when a request is deemed excessive, like we talked about earlier. However, simply requesting a large volume of data does not make the request excessive. In such cases, you should ask the requester to narrow down the scope of their request. So, for example, by specifying a time frame or providing you with a list of documents they specifically want to see. Another situation might involve the requester using the SAR to harass or burden the business financially, in which case the request could be considered unfounded or vexatious. So it might be that they've put a SAR in before and you've responded to that SAR, and then they've put another one in, and then they've put another one in. So that would be considered vexatious or harassment. You are required to justify and document your reasons for relying on an exemption. In your documentation, explain what the exemption pertains to and why you are invoking it. And where we talked earlier about the Information Commissioner's Office, they've got a lovely helpline. They can provide you with more advice about this sort of thing. So if you're relying on an exemption, it's always best to check with them first. And it can also be helpful to explain your rationale to the requester so they understand why their request was not fully complied with. However, only do this if it doesn't reveal the information that you intend to withhold. So let's talk about frequently asked questions. So what if we fail to comply with the subject access request? So failure to comply with the subject access request can result in serious consequences for your business. The individual making the request could file a complaint with the Information Commissioner's Office, which could lead to them doing an investigation and potential fines. And we're not talking small fines here, we're talking large fines that can seriously harm your business. Additionally, non-compliance may damage your organisation's reputation and could be used as evidence in legal proceedings. So it's important, like we said before, to respond within the statutory timeframe of a month and provide the requested information unless there are specific exemptions. So can you charge a fee for a subject access request? In most situations, you cannot charge a fee for responding to a subject access request. However, if the request is clearly unfounded or excessive, or if the individual requests additional copies of their data after a previous request, you may charge a reasonable fee to cover administrative costs. And by a reasonable fee, we're not talking hundreds of pounds, but small amounts. Do we need to comply with a subject access request made by an employee who has now left the business? In short, yes, you do. You must comply with the subject access request, even if it's made by a former employee who's left the business, provided you still hold their personal data. So the key factor is whether the data is still held by your organisation, not the length of time that has passed since they left. So can we redact certain information from the SAR response? And like we talked about earlier, yes, you may redact information that involves third parties, unless, of course, they consent to sharing or if disclosing information would violate other legal obligations. So let's talk about best practice and communication. How can you make life easier for yourself and the organisation you work for prior to the receipt of any SAR? So if you consider how you communicate, for example, do not put in an email or in written format on social media, I think JBlogs should be dismissed. Or even, how can I get rid of JB? As this information could later be requested in the SAR. In these circumstances, if you would like advice from RBHR, then please pick up the phone or request a video call. And it's also important to note that WhatsApp is being used more frequently in employment tribunal cases. So again, be careful what you're putting in social media. Ensure that all correspondence remains professional and refrain from making inappropriate remarks or including anything in writing that could later cause issues. So SARs are also frequently used as a precursor to legal action. Therefore, email chains containing negative opinions, judgments, or decisions about an individual will not be beneficial in any potential employment tribunal. So avoid it at all costs. So what should employers do? So you can identify employees who may need specific training to recognise a subject access request, such as HR staff who may receive requests from employees, And customer-facing staff who may receive requests from customers. So like I talked about the insurance claim earlier. Train these employees on how to identify a SAR and on the next steps in the process. And it's important to have a SAR policy and train managers and staff how to implement it. The policy should outline how to document requests, especially those received by phone or in person. For verbal requests, you can follow them up in writing to confirm the requester's identity and to clarify details to avoid any potential misunderstandings. And retention is extremely important as well. So keep on top of your data retention and do not keep personnel records for longer than is legally necessary. And as we said before, we do have policies that will help you with this. So does anyone have any questions? I'm hopeful that the chat function is now fully operational. So if you do have any questions, please put them in the chat box. Bit of a short and sweet webinar today, so keeping it brief so that we don't lose people's interest with the subject, because obviously subject access requests aren't always necessarily super exciting. But hopefully we've given you some idea of what to do should you get one. Okay. I'm not receiving any questions through the chat right now, but that might be that no one's got any. But if you do think of anything afterwards, feel free to email either myself or Beck, and we'll happily respond to any questions that you have. Okay. So finally, about RBHR consultancy. Just a recap of the services that we offer. For those of you who are already clients of RBHR, you'll be aware that you can pay for a time bank if you have a specific HR query which falls outside of your retainer. We also provide a lot of different training, and we can provide training on subject access requests if that's something that you need for your business, including how to spot one, how to deal with it, and best practice like we talked about earlier. Next slide, please, Beck. So thank you everyone for joining us for today's webinar on subject access requests. I hope that you found it informative. And if today's topic is of concern to you and you would like further information, then please reach out to us at RBHR via the inquiries@rbhr.co.uk email address. Equally, please feel free to visit our website because we have got more information on there as well. And it's goodbye from me and goodbye from Beck. Thank you very much.